Hearing the appeal of Gjelosh Kolicaj against Civil Estate for the Home Department.
Yes, Mr. Lambert.
My Lords, good morning. My Lords, I appear on behalf of the Appellant Secretary of State with Ms Wakeman today. Mr Kolicaj and Mr Hodges appear on behalf of the Respondent, Mr Kolicaj. This is the Secretary of State's appeal against the decision of the Court of Appeal of the 17th of January this year. The case concerns the issue of procedural fairness in the context of deprivation of citizenship under Section 40, subsection 2 of the British Nationality Act 1981. The respondent, Mr Kolicaj, was deprived of his British citizenship status by a decision of the Secretary of State dated the 22nd of January 2021. You will find that, although I don't ask you to turn it up just yet, behind tab 33 at page 339 of the bundle. His initial appeal to the first tier tribunal was rejected. That's at tab 7, page 145 of the bundle. But an onward appeal to the upper tribunal was allowed on the 13th of November 2023. That's behind tab 6, page 120 of the bundle. Again, I don't ask you to turn any of that up just yet. By its decision, the Court of Appeal, Lords Justices Underhill, Dingemans and Edis, indicated that they would have allowed the Secretary of State's appeal on a single ground against the upper tribunal's decision. However, the Court decided that the Secretary of State's decision was flawed for a different reason. Specifically, the Court held that the notice of decision to deprive Mr Kolicaj of his British citizenship and the accompanying deprivation order were issued and maintained in a way that was procedurally unfair. Accordingly, the Court held that both fell to be quashed. And see for those critical findings paragraphs 27 to 30 of the Court's judgment behind tab 5 at page 113 of the hearing bundle. And again, I'll be going to that in detail just in a moment. The reason, as my Lords will have seen from the written cases for this conclusion, was that the Court held that in the absence of what it termed a full appeal on the merits, the Secretary of State ought to have said, at the point of notifying Mr Kolicaj of the deprivation decision, that she was willing to review her decision by conducting a merits-based evaluation in the light of any representations or evidence that he supplied, and that she would in fact then carry out precisely that review on the merits. That critical part of the Court's reasoning is at paragraph 29 of the Court's judgment. The background, though, and indeed the foundation for that finding, was the Court's acceptance that there was no error of law in the Secretary of State not offering Mr Kolicaj a right to make representations before the decision was made. It was only after accepting that submission on behalf of the Secretary of State that the Court of Appeal went on to consider and accept the alternative submission that fairness required representations to be invited and considered on their merits after the decision was made and served. We say that decision was wrong in law for 4 reasons. I'll develop those submissions in a moment, but in summary, can I headline them now so that you have a note of where I'm going? We say the Court misunderstood, first of all, the purpose of the statutory notice provision in Section 40, subsection 5 of the Act. Secondly, the historic scope of deprivation appeals. Thirdly, the nature of the deprivation appeal in general. And fourthly, the background to the decision-making in Mr Kolicaj's own case.
Sorry, the third was?
The third was the nature of the deprivation appeal in general.
And the fourth?
And the fourth is the background to the decision-making in Mr Kolicaj's own case. We also say that the attempt now to defend the Court of Appeal's decision in my learned friend's written case as being premised on a distinction between the procedural protections available in the FTT as compared to SIAC is not made out for 2 reasons. The first is that that was not in fact the basis of the Court of Appeal's decision. There is no trace of that reasoning anywhere in the Court of Appeal judgment. And the second is that in any event, we say that is wrong as a matter of legal analysis. The differing procedural protections made in the SIAC rules are explained by the need in SIAC to repair the procedural deficit caused by not providing the subject of a deprivation decision with the full reasons or evidence for the decision in question. That is why the rules are different. But before developing those submissions, may I begin by way of a contextual submission by outlining some key features of Mr Kolicaj's offending background and case that need to be borne in mind when considering how this appeal fits with the court's previous consideration of the deprivation regime. Can I begin with that contextual submission? I'm not going to go through the background in any great detail, as my lords already obviously have that, but I just want to make one or two points that we say are obvious but important about how this case fits into the line of deprivation cases this court has recently held. First, like many of the recent deprivation of citizenship cases to come before this court, so Begum, U3, N3, this is a case concerning the exercise of the power under section 40, subsection 2, to deprive based on an assessment that deprivation would be conducive to the public good. However, unlike those cases, this is not a case where that assessment is founded on an intelligence-based assessment of the individual's conduct, which is denied by the person deprived. On the contrary, the basis for the Secretary of State's assessment in this case, that deprivation would be conducive to the public good, is the defendant's criminal conviction. Moreover, that criminal conviction was based on the defendant's own guilty plea. Now, the offence in question was a serious one. It was conspiracy to remove criminal property from England and Wales. Mr Kolicaj received a sentence of 6 years on a guilty plea. That was reduced from a sentence of 8 years because he pleaded guilty early, so he had a 25% reduction. Can I show, my lords, some of the key parts of the findings on which that sentence was based in the sentencing remarks of Her Honour Judge Kent at Kingston Crown Court? You'll find those behind tab 38, page 3, beginning at page 367. In fact, the remarks begin at page 368. My lords, I'm grateful. You'll see there, starting at page 368 at letter B, the indictment period was from the 1st of October 2016 to the 30th of January 2018, so a period of 1 year and 4 months. That's the period in which the offending was charged and is relevant, of course, to the sum that was taken out of the country. The circumstances are described at paragraph C onwards. You'll see there was a conspiracy to remove large quantities of criminal money from the jurisdiction, so these were the proceeds of crime. The money was contained in suitcases checked onto commercial flights that went mainly to Thessaloniki or Brussels, where a relative of Mr Kolicaj and his brother was there to receive it. I should say there were 3 individuals charged and sentenced on this occasion, Mr Kolicaj, his brother, and a Mr Phaeton Sibiri. You'll see that the judge concluded that the 2 brothers were organisers in the conspiracy and they controlled the couriers. They also took money abroad themselves, and then the couriers are there named. And you'll get more details of the conspiracy going down the page. I don't go through all of them, but if you look at letter F, you'll see the sort of control that was being exercised. The Kolicajs took the couriers to the airports, watched them check in their cases, supervised a number of them. The control and supervision was such that it involved also flying on a number of flights themselves to ensure that the couriers checked the suitcases all the way to the destination. So there was a high degree of management there. You'll see that the evidence was that between them, they took 65 flights. You've got the locations there. There were 3 interceptions, and the sums of money intercepted are listed at the bottom of the page and the top of the following page: £180,000, £100,000 and €100,000 on the 3 occasions. Moving down on the next page, 369, between letters B and C, you'll see the judge's conclusion that she was satisfied this was a well-planned conspiracy with a considerable amount of sophistication. various techniques used to avoid detection. Again, I don't go through all of them, but you'll see a number of them there. You'll see at letter F the use of a variety of phones and vehicles to achieve the deception that was required in order to carry out the conspiracy. And then at letter G, I'm satisfied the judge says that both Kolicaj were organisers with a leading role in the group criminal activity over the timescale of the indictment, one which persisted even after individuals were arrested and cash was seized. So the arrest of some of the couriers did not actually stop the conspiracy, and there's some more detail on that in one of the documents I'll take my lords to in just a moment. So that leads again to the conclusion that the Kolicaj had a leading role. Over the page, more details. You'll see at the bottom of page 370 the total estimate of the conspiracy is given. The Crown put an estimated value on the conspiracy at just under £8 million. That's, of course, within a relatively short indictment period for this, 1 year and 4 months. Then you'll see at letter A on page 371, this was indicative, the judge said, of money laundering on a serious organised basis. That, of course, was an important finding because this was a deprivation based on involvement in serious organised crime. And then at the bottom of the page, finally, you have the calculation for the reduction in sentence for the early guilty plea, the reduction of 25%. All of that, my lords, is admitted and not at any stage in dispute. So my first submission on the factual background is that while this case shares the same statutory context with the earlier deprivation cases in this court, namely section 40 subsection 2, it is based on a very different factual framework, which of course explains why it went to the FTT and not to SIAC. First of all, it involves admitted serious criminal conduct. Secondly, there is no dispute of fact about the conduct providing the basis for the deprivation decision. And thirdly, therefore, there's no place here for any closed evidence or withholding of material in relation to the assessment of involvement in serious organised crime which underlay the deprivation decision. Mr Kolicaj knew everything about the basis of the decision that there was to know. And of course, when my lords come to consider in due course submissions about the distinction between procedural protections required in SIAC and procedural protections required in the FTT, my submission is going to be that there is no fundamental distinction between the two, but to the extent that the rules are different, they're there to cure a very different sort of problem, which is the inability to tell people in SIAC what the case is that they face. And that is, of course, why one has detailed exculpatory provisions and provision for the involvement of special advocates there. Well, secondly, under this submission about context, both the recommendation from the National Crime Agency to the Home Secretary and the ultimate decision from the Home Secretary were squarely based exclusively on this admitted criminality. Can I show you the NCA recommendation, first of all, which is important for a second point as well? That, my lords, will find behind tab 36, beginning at page 359. And you'll see it begins in the way that recommendations of this nature usually do. It summarises the case for the Home Secretary. You'll see it's dated 19th of October 2020, written to the then Home Secretary. Draws her attention to the case of Mr Kolicaj, summarises the case against him under the summary heading over the page. You then have a summary of the interceptions and the effectively criminal findings from the sentencing judge. You then have the recommendation on page 360, and there are 2 points added there that I just wanted to focus on for a moment. The first one is under the second paragraph under the heading recommendation. You'll see there the most senior figures influencing Albanian organised crime groups remain in Albania itself. As a consequence, the physical conveying of criminal profits in the form of cash back to that country is an essential element of their business model. This enables them to continue to undertake the full range of serious organised crime, both in the UK and abroad. I pause there. That, again, is an important contextual finding in a case about serious organised crime. It illustrates the significance of the role and criminality of Mr Kolicaj why he was playing a part in a much bigger operation and why his role was just so significant. Because ultimately the most senior figures remain in Albania. So insofar as this was an operation involving the transport of monies derived from criminal conduct from one jurisdiction to another, his role was absolutely crucial. The second point to make is that, and it's a point that was flagged in the sentencing remarks, but one has a little more detail here, is that the criminality continued after the arrests. That, of course, is relevant to why deprivation and not just prosecution was necessary here. You'll see in the next paragraph that the activities of the brothers were conducted over a protracted period. There's reference to the sophistication. And then in the fourth line, the fact that the brothers continued to organise and conduct further consignments, even after the arrest of 2 of the couriers, was assessed to be an aggravating factor. In addition, 4 days after the arrest of Mr Kolicaj, he flew direct to Albania. It's the NCA's assessment that the purpose of this trip was to meet with the intended recipients of the cash to plan a response to the disruption of the OCG, the Organised Crime Group. Their behaviour reflects a determination to continue their unlawful activities regardless of intervention by UK law enforcement, ultimately only curtailed by their incarceration. Given the level of determination, it's likely they will continue to pose a risk following completion of their sentences. So in other words, we say that that's, again, highly relevant to why deprivation was considered. But also important to note, following that, the final substantive paragraph indicating that consideration had been given to private life with respect to Mr Kolicaj. You'll see there's an acknowledgement that he was established in the United Kingdom since 2005. There was a family life with his wife and 2 children. But then this: given the seriousness of his criminal conduct, only the most exceptional human rights considerations could outweigh it, which he will have ample opportunity to raise, given that both decisions attract a statutory right of appeal. In addition, as his wife originates from Albania and their children are still relatively young, it would be viable for them to maintain their life back in their home country. Well, my lords, what I say about that particular paragraph is this: insofar as at this stage the NCA was considering and making a recommendation to the Home Secretary on input representation from Mr Kolicaj, the NCA, as a referring body, envisaged precisely the model that this court in U3 has said is the way to achieve procedural fairness, namely through the later appeal against a deprivation decision and also deportation decision. You'll see this is a case where, although the hearing in this court is to do with deprivation, it was always considered that deportation would be a likely outcome as well, and that was part of the ministerial submission to the Secretary of State. Indeed, deportation action has been commenced. But the point being made by the NCA is he will have an opportunity to submit representations which can be considered as part of the appeal process. Now that, of course, predated by some time this court's analysis in U3, but we say it's absolutely the right analysis, and we say the one that applies squarely here. And so when one considers, in the next document through the ministerial submission, references to the making of representations, that has to be seen through the prism of the recommendation the NCA was making. The NCA was squarely saying to the Secretary of State, Mr Kolicaj will be able to make representations and they will be considered in the appeal. You will have seen there was some concern on the part of the Court of Appeal, both in the judgment, the main judgment of Lord Justice Edis, and the short concurring judgment of Lord Justice Underhill. That's Lord Justice Edis at paragraph 11, Lord Justice Underhill at paragraph 40. To the fact that there had been reference to representations being possible. And they said, well, that's not the case. In fact, the prism to review those representations through is the appeal. That's what the NCA is saying. My lords, can I then take you to, finally, to the ministerial submission?
Just before leaving
yes.
page 360, it would have been open to him on an appeal to say that, to provide some reason for going to Albania, apart from the one
it would.
That the NCA assessed him as assessed as the reason.
Absolutely, my lord.
And so there's that's a factual issue he could have raised if he wanted to.
On an appeal, absolutely. My lord, that's absolutely right. And there's no dispute from me at all on behalf of the Secretary of State that that was entirely open to him. You will have seen in the first tier tribunal judgment, paragraphs 4 and 30, that Mr Kolicaj produced a lengthy witness statement in this appeal, but declined to give evidence. So he had the opportunity to produce evidence. He had the opportunity to produce evidence if he wanted, even though there had been a criminal conviction against him based on his admitted facts. On this point, this wasn't a matter that the judge sentencing him considered, but he could perfectly adequately deal with that by way of the appeal to the tribunal. And indeed, that's precisely the kind of point that normally one would expect an appellant through evidence, who could then be cross-examined on it if they decided to step into the box, to deal with in the appeal. Absolutely no barrier to him doing that at all. So, my Lord, I respectfully agree.
But he declined to give evidence.
He declined to give evidence. So he gave a witness statement. He provided what was described as a detailed and lengthy witness statement in the FTT, but he didn't give live evidence. And indeed, the FTT hearing, as my Lords would have noted from the judgment, was organised with a sufficient time estimate for him to give evidence. So it was fully anticipated that he would do so, but in the end he declined to take up that opportunity. My Lords, can I then move on from the NCA submission and move to the ministerial submission? My Lords will find this behind tab 35, beginning at page 343 of the bundle. It's dated a couple of months later. It's the 17th of December. I should say, so you Lords, my Lords have the geography of the submission, as it were, that it was in the usual conventional way for these kind of documents, a main submission describing the case and recommending action to the Secretary of State, accompanied by a number of annexes. You'll see the very first annex at page 350, Annex A, is the NCA recommendation I've already taken you to. So that point about the appeal was there before the Secretary of State in the first document she was shown. Annex B was then a statelessness assessment. Again, my Lords from recent cases will be familiar with the fact that there is routinely a statelessness assessment carried out to ensure the Section 40 sub 4 guarantee is met. That's at Annex B. Annex C is the ECHR analysis on human rights. That one I'll come back to. That's where some of the representations are referred to. And then Annex D is the Section 55 best interests of the child consideration. There's also a draft letter in Annex E. So just going back to the main body of the submission, you'll see on the first page, page 343, the recommendation is to agree to deprivation, to sign the notice at Annex E, that's the second bullet. And then thirdly, just worth flagging this point, following deprivation, Mr Kolicaj will be liable to deportation under Section 358. That's, of course, the case because he would then no longer have the protection of the right of abode under the 1971 Act, so he becomes liable to deportation under the deportation provisions on the basis that deportation is conducive to the public good. There is, of course, in a case like this, a complete identity between the statutory tests there for deprivation and deportation. We intend to arrange that any appeals against the decisions to deprive and deport from the UK be heard together. Now, that, in fact, did not happen. The deportation appeal, because he was served with deportation paperwork, he made representations which were considered, and a deportation decision was made. That has been stayed behind the outcome in this case. So that's the only distinction to make there. You'll then see a list of the annexes and the discussion beginning on page 345. I don't go through all of that. It summarises the background in the way that my Lords have already seen. And perhaps just worth flagging one thing in paragraph 5. That's a reference to something called the Fiona Johnson submission of the 13th of May. That's 13th of May 2020. That was a ministerial submission drafted by Ms Johnston to the Home Secretary, recommending that the deprivation power be used more routinely in cases of serious organised crime. That is a subject of one of the respondent's notice points that my learned friend raises. I won't say any more about it now. I'll let him develop his submissions. I'll come back to that this afternoon. But just again, to situate my Lords, that is referred to there. The case for deprivation is set out at paragraphs 9 and 10. And again, deprivation is 9 and 10. Deportation is 11 and 12. In deprivation, you'll see that his criminality is described in paragraph 9 as fitting within, squarely within the parameters of the Johnson submission. The reference to paragraph 4 is wrong. That should be paragraph 5. Additionally, the NCA assessed that deprivation of Mr Kolicaj would negate the risk he poses to the UK based on his role in serious organised crime. You'll see then this statement that his criminal enterprise is facilitated by the ease of travel he enjoyed as a British citizen, using the British passport to transport money out of the UK in order to launder it. It is considered that depriving him of his citizenship would be conducive to the public good because it would contribute to preventing and deterring further criminality, in particular from the OCG, of which he held a senior and controlling role. And I've shown you already the passage in the NCA recommendation which shows why his role was so critical in providing the bridge between criminality in the UK, producing the criminal profits, and then the money laundering in Albania, where the most senior members of the crime gang lived. You'll see at paragraph 10 also, though, that deprivation is not sought solely to sanction the criminality, but also as a tool to protect the public, because, of course, stopping him laundering the money here stops the ability to use the proceeds of crime. There's a direct impact on criminality in the UK. So it's a highly important deprivation, this one.
Is the word sanction used in the sense of punishment?
Yes, I think that must be, my lord, absolutely. It's not just a punishment for the criminality, it's also public protection. And that's an important conclusion, because, of course, it's conduciveness to the public good that is the test here. So that would be an important part of the Secretary of State's consideration. And indeed, again, if one stands back for a moment and considers the NCA's analysis which fed into that, their position was that having stopped the gang, having stopped some of the transactions taking place and carried out arrests, the criminality continued. And in fact, their assessment was that Mr Kolicaj then travelled to Albania in order to discuss how the disruption could best be managed. So sanctioning the criminality had not, in fact, stopped the harm to the public good that was occurring. That's why deprivation was so significant. There's a reference, and quite a detailed reference, to the immigration position of his wife. I don't need to go through that. It's dealing with her own specific position under the immigration rules and the position of the children, and there's a finding of proportionality at the end of the paragraph. Then in paragraph 11 you have the case for deportation. I don't go through all of that, but just highlight for my lords the end of the paragraph, 5 lines up. You'll see that the submission says any representations that deportation would breach either the Refugee Convention or his human rights under the ECHR will be fully considered. The refusal of an ECHR protection claim will likely afford Mr Kolicaj an in-country right of appeal to the first-tier tribunal, Immigration and Asylum General. So, insofar as representations, taking this as a whole, are considered, they are only raised in the body of the submission in the context of deportation, and the point is made that they will be considered in the context of the appeal. So in the body of the representation actually seeking the Secretary of State's agreement, there's no reference to representations in relation to deprivation. You'll see there's a blacked out section under the legal considerations. I should make it clear the only redactions in any of the documents here are for LPP. There's nothing here to do with national security or serious organised crime, intelligence sensitivity or anything of that nature. One then moves essentially to the annexes. You've seen Annex A. Annex B is not relevant here, the statelessness consideration, but Annex C, if I can ask my lords to turn to that, at page 354, you'll see consideration. It begins with consideration of Articles 2 and 3 in regards to deportation. That, of course, is the most obvious way to consider them, because it would only be on deportation that Articles 2 and 3 would be engaged or in any way potentially, theoretically, even at risk. In paragraph 6, you'll see that it said, once Mr Kolicaj has been informed that it's our intention to deport him, he will have the opportunity to make representations, which should be fully considered. Should he raise any grounds that deporting him to Albania will breach Articles 2 and 3, they will be carefully considered. I pause there. That is dealing solely with deportation. That is also completely standard practice in the deportation context. In fact, it's necessary in order to give rise to an in-country right of appeal against the decision to make a deportation order. The way that deportation procedure would proceed normally would be that the Secretary of State would make what's called a Stage 1 deportation decision, indicating an intention to deport somebody and seeking representations in response. The individual would then be able to raise whatever representations they wanted, typically on human rights or refugee protection grounds. The refusal of those representations would then generate a right of appeal to the tribunal, because it would be a refusal of a human rights claim under the relevant provisions in the Nationality, Immigration and Asylum Act 2002, Section 82 of that Act. So that was describing completely conventional process and making clear that those representations would be considered. They were. There has been an appeal generated here, and it's currently stayed. Then there's a reference to consideration of Article 8 in relation to both deprivation and deportation in the section which follows. And the fair point is made that his full circumstances aren't known, so only preliminary assessment can be made. He'll have the opportunity to make representations against each decision, and then the point is made that he's been here for that period of time. His circumstances will only be known once those full representations are made. You will then see at paragraph 8, if he's deprived of his citizenship, he may seek to argue that the decision is disproportionate, and so on and so forth. And then further at paragraph 10, Mr Kolicaj may argue that deportation is a reasonably foreseeable consequence. He'll be served with liability to deportation notice, acknowledge that there's an intention to deport. He'll have the opportunity to make full representations. So those are the further references to representations being made. Again, with paragraph 7, although that does refer to representations in the context of both deprivation and deportation, the context, of course, is set by the earlier annex from the NCA, saying he's got a right of appeal against both those decisions. So there can be no serious suggestion, we say, that the Secretary of State was under any misapprehension that she would be later having to consider representations made by Mr Kolicaj. There was no request to her to delay her decision, to take something like a minded to decision, and then to revisit it once the representations came in. It was absolutely clear, because of the way the NCA had framed their recommendation, which was front and central in the case for deprivation, that any representations would be considered through the appeal process. And as I say, for completeness, you have Annex D on the best interests of the child. We say that's a full and fair consideration of those interests. There is a reference at the end of paragraph 3, again, to the fact that he may make representations in due course to the best interests of the child. Realistically, it's very difficult to see how that could be in relation to anything other in substance than deportation being particularly relevant there. My Lords, all of that leads to the notice of decision that you have behind tab 33, beginning at page 339 of the bundle. At this stage, Mr Kolicaj was still in prison, so you'll see there's the usual cover letter asking for the letter to be conveyed to him, a letter to the prison governor. It's dated 22nd January 21. The substantive notice is over the page, at page 340. I don't seek to go through the contents. You'll see that the reason in the second paragraph, after he's been told that he's going to be deprived, is the conviction. And the circumstances of the conviction are described there. The penultimate paragraph on the page describes them as being very serious in nature, containing an element of organisation and collusion, rightly justified as participation in serious organised crime. And there is a reference then to paragraph 55.4.4 of the nationality instructions. Just for my Lord's note, you have those. That was the then current policy on deprivation. You have them behind tab 40, and at page 453, conduciveness to the public good is defined as meaning deprivation of the public interest on the grounds of involvement in terrorism, espionage, serious organised crime, war crimes, or unacceptable behaviours. I don't seek to turn it up, but that's what the reference is dealing with. It's locating this within the applicable policy. Then over the page, you find the finding that he would not be stateless, and then there's consideration of the best interests at section 55. Notice of his appeal is given to him under section 40A1. As I've said already, this is not a SIAC case. and therefore there is no reference to certification or anything of that nature. And then it said that an order under section 42 will be made after you've been served with a notice. That order you have on the next page in the bundle, page 342. My Lord, stepping back against that background, and I apologise for taking a little time to go through those documents, but it is necessary in order to set in context the legal submissions I'm about to make. Against that background, this is a case, you will see, that involves the same statutory power, deprivation on the grounds of conduciveness to the public good, under section 40 sub 2 of the Act, as the other cases this court has heard recently, but exercised in very different circumstances and on a different basis from the likes of Begum, U3 and N3. The decision was taken on the basis of admitted, very serious criminal conduct, and there is no element of closed consideration here. There's no consideration of secret intelligence. There's no holding back of material from Mr Kolicaj in the public interest. As I've indicated, the only redactions are for LPP. The relevance of that distinction, I say, becomes clear when considering Mr Kiriko's argument that an additional element of procedural fairness was required in the FTT because the FTT rules do not contain the same provisions as those in SIAC. That'll be one of my closing submissions. That submission is wrong, we say. The fact that this is an open FTT case based on admitted criminal conduct meant that the additional procedural protections built into the statutory appeal process in SIAC through the use of exculpatory reviews, special advocates, are completely unnecessary here. There's no procedural or fairness deficit in the FTT vis-à-vis SIAC, by contrast, which needs to be cured. My Lord, with that background, can I come to my submissions on ground one? So ground one, of course, is that the Court of Appeal erred in law in finding that procedural fairness required Mr Kolicaj to be granted the right to make and have determined on their merits any further representations after notification of the deprivation decision. May I begin to make good my submissions on this point by taking you to the Court of Appeal's judgment. It's behind tab 5 of the key documents in the appeal bundle. It begins at page 92. I don't seek to go through the earlier passages in the judgment. Can I take my lords to where the analysis on this ground begins, which is on page 112. And my lords, on page 112, you will see the heading, Procedural Fairness Respondent's Notice, Ground 1. So this ground was the first respondent's notice point argued by my learned friend in the Court of Appeal. You'll see at paragraph 25, the court begins with a reference to the classic statement of principle on the prior representations requirement in public law from the Bank Mellat case, namely that anyone who would be foreseeably significantly detrimentally affected by a decision must be given the opportunity to make prior, I stress prior, representations unless either the right is expressly or impliedly excluded by the statute, or alternatively circumstances in practice make it impossible, impractical, or pointless to accord such a right.
Read to another pages.
I think you can proceed, Mr. Blundell.
Well,
Sorry,
sorry
Mr.
if I should have
Blundell, there was a
stopped
technical problem that I hope has been resolved. I'm very sorry to interrupt your submissions.
My Lord, not at all. I hope I didn't continue when I shouldn't have done. My apologies. My Lord, so just to recap, I've taken the court to the beginning of the analysis of this passage of reasoning in the Court of Appeal's judgment, page 112, paragraph 25. It begins with, as I said, the classic statement of reason from Bank Mellat. Then at paragraph 26, perhaps one might think, interestingly, in the context of what this case went on to decide, the court sets out a passage from the Balajagari, that's another Court of Appeal decision case, the Balajagari decision. The full Balajagari decision, I don't ask you to turn it up, but for your notes, is behind tab 70, page 1180. But you have the relevant extract here. Could I just ask the court to read that paragraph 60, which is quoted in paragraph 26?
Well, the words in the first sentence are quite important, unless the circumstances of a particular case make this impracticable.
Yes. Well, my lord, absolutely. And indeed, what the passage then goes on to set out are precisely the reasons why post-decision representations are not usually a good substitute for the making of prior representations, for what one might think are perhaps completely obvious reasons. And there are three reasons identified there. First of all, the need to ensure that the decision maker is fully informed at the point when the decision is still at a formative stage. Reference to formative stage, there recalls some of the case law, of course, on consultation and the like, the Sedley requirements, the Gunning requirements. When representations can make a difference. If you make representations, you want them to make a difference in the decision to be made. Secondly, it shows respect for the individual whose interests are affected. And thirdly, it recognises that decision makers may unconsciously, in good faith, be defensive about decisions already taken. That, of course, is why Parliament accords rights of appeal in certain cases against particular types of decision. So what this passage is doing is, absolutely, I agree, my lord, stating, essentially beginning with a restatement of the Bank Malat issue about impracticability, but then explaining why post-decision representations aren't a good substitute. And we say that's particularly striking in this case because, of course, that's precisely what the Court of Appeal went on in the face of a statutory appeal, the existence of a statutory appeal, to say should be accorded here. So this was not the approach that the court took. And then at paragraph 27, the court begins by rejecting the first of the approaches in Bank Malat, namely the express or implied statutory exclusion. If I can just headline a point here, I accept entirely that there is no express statutory exclusion here of the procedural fairness requirements for prior representations. This isn't a statute which expressly says that. Relatively few statutes do. However, a decision I'll take, my lords, to just a little later, which is Begum number 2 in the Court of Appeal, which was upheld through a refusal of permission in this cause, specifically considered that actually the right to prior representations was impliedly excluded by means of a process of statutory construction that I can show the court in due course. But I'll come back to that at a later moment. So paragraph 27, it rejects the first Bank Malat test. Lord Justice Edis, giving the judgment here, says that the statute doesn't expressly provide there should be no right. In my judgment, it doesn't do so by implication either. And he then says this: the purpose of section 45 is to enable a person who is the subject of a decision to make a deprivation order, to bring an effective appeal before the order is made. Now, pausing there, that is wrong. And that is what we say is the first of the Court of Appeal's errors in this analysis. The suggestion that the statutory purpose envisages an effective appeal before the order is made is inconsistent with this court's decision in the case of N3. My lords, can I make three submissions on this point? First of all, N3 confirms that the Secretary of State is entitled to make a deprivation order at a time of her choosing after the deprivation decision has been notified. There is no minimum period that must elapse, and the Secretary of State may make the order immediately after giving the notice. Can I just briefly take my lords to the N3 decision to make good that first proposition? It's behind tab 88 of the hearing bundle, beginning at page 1787. I should say it's post-dated the hearing and the decision in this case. So it wasn't a decision that the Court of Appeal could have taken into account. Perhaps I should begin with a passage at page 1799. My Lords will recall, of course, the issue here was the effect of the Secretary of State having conceded the statelessness question and what the British citizenship status of an individual was in the interregnum between the order having been made and then effectively the appeal being allowed. None of that concerns us today. But if my Lords would look at page 1799, you'll see at the top of the page a heading, the nature of an appeal to the first-tier tribunal or SIAC. I'm headlining a point I'm going to make later on here, but I might as well do it as I'm in the documents. This is an analysis of the way the statutory appeals provisions work. It applies, as the heading suggests, to both the first tier and SIAC. There's no distinction. And you'll see at paragraph 36, first of all, it's usual for more information to be available before the appellate body than was available to the Secretary of State when making the deprivation decision, for instance, in relation to statelessness, common for expert evidence to be called. Secondly, in hearing the appeal, the appellate body makes its own decision on all the facts and evidence before it, not restricted to the facts known to the Secretary of State when making the deprivation decision. I make that point because, in a sense, that flows through all the arguments that arise in this case before this court, whether or not the same approach should be adopted as in N3 and U3 to the proceedings in the FTT and SIAC. And we say it's abundantly clear that certainly this court envisaged that those critical elements of procedure in both tribunals, the tribunal and the commission, were essentially the same. And that's also particularly relevant given my Lord Justice Stevens' question to me at the outset about the point to do with travel to Albania that had been dealt with in the NCA submission but was not part of the facts upon which Mr Kolicaj was sentenced. Precisely because of what is said here in N3, that's why I said that this is the sort of thing that Mr Kolicaj could fairly raise before the first-tier tribunal without any difficulty, and the first-tier tribunal would be required to consider that. Over the page, if I may, you'll see the next heading is several points in relation to sections 40 and 40A of the 1981 Act. Section 40A, of course, being the appeal to the first-tier tribunal. You'll see that's paragraph 45. There is a process for making a deprivation order. Must first decide to make a deprivation order, that's the deprivation decision, and must give written notice under section 40 sub 5. Necessarily the reasons for the order will identify whether it's to be made under sub 2 or sub 3. Sub 3 is the fraud provision. And if under sub 2, that the Secretary of State is satisfied that it will not make the person stateless. And then this, there is no requirement on the Secretary of State to await the response from the person concerned to the written notice before making the deprivation order. Rather, once the written notice has been given, the Secretary of State, at the time of his or her own choosing, implements the deprivation decision by making the deprivation order itself. And then my Lords go on to say the fact that there is no statutory requirement as to the period after the written notice of the deprivation decision is given within which the deprivation order is to be made does not mean there are two decisions being made, rather there's one decision followed by implementation. And then again, picking it up towards the end of paragraph 46, 3 lines up, there is no separate stage when the Secretary of State remakes the decision in order to make the order. Rather, the Secretary of State, based on the earlier decision, simply proceeds by making the order. And there's further provision about the appeal at paragraph 48. So that's why I say as my first submission that N3 confirms the Secretary of State is entitled to make a deprivation order at the time of his or her own choosing after the deprivation decision has been notified. No minimum period must elapse. Secondly, my second submission specifically in relation to the appeal provisions, the court in N3 went on to hold that following the statutory amendments to section 40A, the Secretary of State could make the deprivation order during the currency of appeal proceedings. That analysis is over the page at page 1802. I can just take my Lords to that passage. At the bottom of the page, you will see a reference to section 40A and the former section 40A sub 6. which prevented an appeal being made.
Sorry, you're at the bottom of 1802.
At the bottom of 182. In fact, I'm slightly further up from there. Letter F, my lord.
Ah, right, thank
My lord, I'm sorry, I should have given you the letter reference, my mistake. So at letter F, you'll see the former section 40A6, which imposed effectively a bar on making the order pending the currency of appeal proceedings. But then by virtue of the amendment, the Secretary of State could not make deprivation order while an in-time appeal under section 48 could be brought, or if an appeal was brought until it was determined. The purpose was to enable a challenge to be made to deprivation before deprivation occurred. But then this, at 54, however, the amendment brought about in 2002 was repealed by the 2004 Act. An appeal or a potential appeal no longer has suspensive effect on the Secretary of State's power to make a deprivation order. Rather, the Secretary of State may now proceed to make a deprivation order during the period within which an in-time appeal could be brought, and despite the person concerned bringing an appeal against the deprivation decision. And there's then a reference to the relevance of that to the bringing of immigration enforcement proceedings. You'll see the analysis continues over the page. Paragraph 55 then, 4 lines in, you'll see further that now, because of the repeal of the amendment, the point at which the deprivation order can be and usually is made is before the outcome of any appellate proceedings. The repeal of the amendment affects the time at which the deprivation order can be made, but it has no consequences on the has no impact on the consequences of a successful appeal. Of course, that was the issue in N3. So my second submission is that the court was quite clearly wrong when this passage in N3 is considered to say that the purpose of section 40 sub 5 was to enable a person subject to a deprivation decision was to bring an effective appeal before the order was made. Absolutely not. At least not since the statutory amendments were made. As I say, this decision, N3, was not before the Court of Appeal because it postdates the Court of Appeal's analysis, but equally the court wasn't taken to any of the statutory history that was considered in detail in this court. My third, so we say for that additional reason, this part of the Court of Appeal's reasoning is wrong. But thirdly, the consequence, as we've pointed out in paragraph 54 of our written case, reference for you is page 43 of the bundle, is to create precisely the same possibility of undermining the statutory scheme that the Court of Appeal had found justified not allowing prior representations before the decision was taken. If the court envisaged an effective appeal taking place before the order is made, that would give the person concerned advance notice of the decision that would enable them to renounce their citizenship and frustrate the entire purpose, so that they could lose their appeal, but simultaneously with the appeal, renounce their other citizenship and therefore void the whole process and frustrate the entire statutory scheme. In other words, you could create exactly the sort of risk to the public interest which the court said its analysis avoided. Mr Kolicaj, in his written case, suggests that it must be that the court was meaning here that the representations could just be made at some stage during the currency of the appeal process. But first of all, that's not what the Court of Appeal said. Secondly, the Court of Appeal statement at paragraph 27 is, we say, crystal clear. And thirdly, if that was what the Court of Appeal meant, one might rhetorically ask, well, when exactly? Could one make submissions on the day of the appeal hearing? What would happen then? Would the appeal have to be adjourned for the representation to be considered, the Secretary of State to make further decisions, and so on and so forth? Of course, if an individual makes representations through their evidence submitted in an appeal, the Secretary of State can and will consider that. Indeed, it's in the Secretary of State's interest to do so. If the Secretary of State doesn't do so, it may well be that she's going to have a very difficult time, or those representing her are going to have a very difficult time on their feet before the Statutory Appeal Tribunal. It's not in the Secretary of State's interest to continue with an unwinnable case. And I'll come back in a little moment to some of the statutory rules provisions which allow for the narrowing of issues between the parties. But the proper forum for doing that is in the appeal process. So, my Lord, concluding on that first error in my submission, that was the first of the errors that the Court of Appeal made and which I referred to in opening, it misunderstood the purpose of the statutory notification provisions in section 40, subsection 5. That was a relevant and significant error because the court was identifying here what it considered to be a core part of the statutory purpose in the notification provisions and their relationship with the right of appeal. It was construing the statutory provisions as a whole. And as I'll show my lords in a moment, it was concerned specifically about the scope of the right of appeal that drove the court's reasoning. So this first error as to the purpose of notification being directed to the scope of the appeal is highly material, we say, and shows that it misunderstood in quite a significant way the statutory context from the outset. My lords, can I return then to paragraph 27 of the Court of Appeal's decision, again at page 113. After that third sentence that I just focused on, my lords, you'll see the court says that the provision, section 45, has been applied differently in section 40, subsection 2 cases since events in Rochdale. The statutory purpose is clear. That is a reference to the Rochdale grooming scandal, which the court has summarised earlier in its judgment. And my lords will have seen in the written cases and in the judgment reference to the fact that following the Rochdale sex abuse grooming scandal, a number of individuals criminally convicted of involvement in those events had their citizenship taken away in circumstances where they were dual citizens, but because they were notified of the intention to do so before a deprivation order was made, in some cases, not all cases, but some cases, the individuals concerned renounced their other citizenship and therefore made the making of a deprivation order effectively impossible and frustrated the statutory purpose. So that is why the Home Secretary started to adopt a process and procedure by which she would notify the decision and very shortly thereafter make the order to prevent the individual having an opportunity to frustrate the statutory purpose. This, of course, being by definition a process adopted in cases where the starting point was that it was in the public interest to deprive the individual. The court then, however, proceeded to make the further point straight after that sentence as follows. At the time of the enactment of the 1981 Act, that was understood to be an appeal on the merits. Well, my lords, that is the second error in the Court of Appeal's analysis, the historic scope of appeal rights. Again, can I make these points about that? As my Lord Reid pointed out in the first Begum decision, and I'll take you to it now, the right of appeal against a deprivation decision was in fact only introduced with effect from the 1st of April 2003. Begum 1 is behind tab 72 of the hearing bundle. Can I just ask my lords to turn that up very briefly?
What's the page?
Page 1, so it begins at page 1262, and the page I'm going to is 1284.
You say the right of appeal was introduced in...
So it was only introduced with effect from the 1st of April 2003. And my lord will see that in this passage. So at page 1284, you have a heading just above letter C.
1284.
1284.
Okay.
A heading just above letter C, above paragraph 38, and 3 lines in. I'll begin with the beginning. Appeals against deprivation decisions have an entirely separate history, such decisions not being immigration decisions, as that expression was understood prior to the 2014 Act, without going through the very detailed analysis of statutory history that was involved in Begum 1, which will be, I know, more than familiar to this course. Of course, deprivation was treated in a very different way. One of the errors that had crept into the Court of Appeal's analysis in Begum 1 was in an equivalence being drawn between immigration decisions and immigration case law and nationality or deprivation of nationality decisions and case law, which were treated differently. My Lord then went on to say this: rights of appeal were first introduced by Section 4.1 of the 2002 Act, that's the Nationality, Immigration and Asylum Act, which substituted a new Section 40 and Section 40A for the original Section 40 of the 1981 Act, with effect from the 1st of April 2003. So that's why I gave you that date. and the provisions establish a right of appeal to an adjudicator, currently tribunal. The point is then picked up at paragraph 40. There does not ever appear to have been any statutory provision relating to the grounds on which an appeal under section 2b may be brought, the matters to be considered or how the appeal is to be determined, as mentioned in paragraph 34 above, section 4 of that's the SIAC Act 1997, was repealed on the same date as section 2b came into force. And sections 84 to 86 of the 2002 Act were not applied to appeals under section 2b. So those are the provisions in the Immigration Act which make provision as to matters to be considered, grounds of appeal, determination of the appeal, and so on and so forth. Very important in the immigration context. The same appears to be true of an appeal to the tribunal under section 40A of the 1981 Act. So again, I emphasise that particular passage. It is not the case that this court has only ever been considering the statutory provisions in relation to SIAC. In fact, the court has provided comprehensive analyses at every stage, N3, U3 and BGAM, of both limbs of the appeal process. There is no distinction in the primary statutes drawn between the two appeal routes. You get an appeal, and either you go to the FTT, or if you're certified, you go to SIAC. There are then different procedural provisions within the individual tribunal and commission rules, but that, as I say, is for a very different reason. Parliament drew no distinction. So, my Lord, in my respectful submission, is absolutely right to say that there was an equivalence here. So that's a starting point. The Court of Appeal in this case was saying that at the time of the enactment of the 81 Act, there was an appeal on the merits. Not true. There wasn't an appeal until 2003. And I'll say in a moment that that wasn't on the merits either. You can see the original provision, the original section 40, and it may be worth just turning this up, behind tab 44 of the appeal bundle. Can I ask my lords just to turn to that for a moment? Tab 44 at page 484. And my lords, we'll see if one turns over the page to page 485. So this is the 81 Act as enacted. So this is what the Court of Appeal was describing, but it's not clear that it can have seen it because its description is wrong. On page 485, subsection 6, before making an order under this section, the Secretary of State shall give the person against whom the order is proposed to be made notice in writing informing him of the ground or grounds on which it is proposed to be made and of his right to an inquiry under this section. So all that was done in 1981 was to provide for a statutory right to an inquiry. And then you'll see paragraph 7, if a person against whom an order is proposed to be made applies in a prescribed manner for an inquiry, then the Secretary of State may refer the matter to a committee of inquiry consisting in that way. And then subsection 8 provides for rules to be made. My lords, we've found the rules that were made. We have a copy, if the court would like to see them, that I can hand up now. They're very brief. They're the deprivation, the British Citizenship Deprivation Rules 1982. Can I just hand up a copy of those now? I should indicate I've given these to my learned friend overnight as well, so he's got them. Just so my lords have the full picture.
Thank you.
So my lords, we'll see, as I say, these are the British Citizenship Deprivation Rules 1982. The notice of inquiry process is introduced at Rule 2. At Rule 4, there's provision made for the conduct of proceedings and evidence. And you'll see that the committee shall give to each party at the inquiry an opportunity to address the committee, give evidence, call witnesses and make representations. Committee may receive oral, documentary or other evidence, notwithstanding inadmissibility, a relatively common procedure in commissions and tribunals of this sort, and so on and so forth. Then over the page again, at Rule 8, notification of the committee's conclusions. The committee shall cause their conclusions to be recorded in a document signed by the chairman and shall cause a copy thereof to be sent to each party. Subject to paragraph 3 below, the committee shall furnish a statement, either written or oral, of the reasons for their conclusions if requested, whether before or after the parties have been notified of their conclusions in accordance with paragraph 1, to state the reasons. And then there's a carve-out at subparagraph 3 to protect national security, essentially. Again, a provision one would expect in an instrument, statutory instrument of this kind. What that is not is an appeal on the merits. In fact, it would be difficult to think, to conceive of a statutory process of inquiry more further removed from a true appeal on the merits, which the Court of Appeal said existed in 1981. That is simply wrong. So we just thought it might be useful for the Court to see the full scope of it.
Both the Act and the rules appear to be silent as to what the legal consequence
Exactly.
of an inquiry, what do they call it, the inquiry's conclusions.
Quite. Completely silent. So it doesn't say, for example, the Secretary of State must comply with the conclusions that are communicated to him or her, or the Secretary of State must give reasons if not complying with the conclusions, or anything of that nature. So it's entirely a process which would inform the Secretary of State. No doubt the Secretary of State could take into account and would have taken into account those conclusions, but there is absolutely no mechanism for enforcing those conclusions of the inquiry against the Secretary of State. Comparable perhaps to the system that used to exist with the predecessor to SIAC, the old committee of, I think it was called Three Wise Men, which is effectively a committee of experts, as it were, to whom the Secretary of State could refer national security cases where decisions taken on national security grounds were challenged. The inadequacy of that process was revealed, of course, by the Shahal litigation, Shahal in the United Kingdom, and that led, in the mid-90s, that led to the introduction of the SIAC Act in 1997. So a very, very light touch process for allowing somebody an opportunity to challenge in some way notification that it was proposed to deprive them.
And just so that I fully understand, the 1981 Act was the first occasion on which the Secretary of State had the power to deprive of citizenship. Is that right?
So there is earlier legislation going back, I think, as far as 1914.
Right.
But the 1981 Act is the modern incarnation. It was a consolidating statute, the British Nationality Act. It completely reformed all the categories of British nationality, overseas citizenship status, British overseas territory citizenship status, all those different categories, and introduced the modern provision for deprivation of citizenship. So that there is provision going back as 1914, and we can certainly assist the court with that, if that would be of assistance. But this is where the modern system begins. The reason that most of the cases begin in 1981 is because the deprivation provisions were, if you like, the flip side of the consolidated coin on nationality law in the 1981 Act.
As I recollect, there's a discussion of this in some detail by Lord Sumption in a case obviously some years ago.
Yes.
Which was to do with how rights to citizenship passed through the patrilinear line, but not the matrilinear.
I think that might be the Johnson case.
That'd be it, yeah.
Yes, that's absolutely right. And in the Johnson case, this court found that there was discrimination, unlawful discrimination, through rights to citizenship passing down in that way, and that led to quite a significant change in the law, an amendment to the 1981 Act. That's absolutely right. Oh, that's right. As I say, if that would assist, we can go further back on that, and we're very happy to do so. But, my lords, those are the provisions as they existed in 1981. As I say, nothing could be further from a statutory right of appeal on the merits. It is not clear where the Court of Appeal really derived that analysis from, because it was inconsistent with Begum 1, which it did have before it, and it referred to Begum 1, it was inconsistent with the statutes. And, my Lord, finally, by reference to Begum 1, my Lord Reid's analysis at paragraph 68 of Begum 1, just to give my Lords the reference, and now very well known and oft-quoted passage, paragraph 68 on page 1292, my Lord said that appellate courts and tribunals cannot generally decide how a statutory discretion conferred upon the primary decision-maker ought to be exercised or exercise the discretion themselves in the absence of any statutory provision authorising them to do so in general, restricted only to what are then effectively classic public law or administrative law grounds of review, albeit in the context of a true appeal. And my Lord, putting those provisions together and responding again to my Lord Briggs's point, there is no such provision here at all. There's no provision whatsoever telling the Secretary of State what to do as a result of any conclusions, as they are described, that might be provided to the Secretary of State by the Committee of Inquiry. There's certainly no statutory provision of the sort this Court envisaged in paragraph 68 of Begum number 1 that would be required to enable a decision-maker to step into the shoes of the decision-maker themselves. So, my Lord, that we say is the second of the significant errors in this short passage by the Court of Appeal. It's an error as to the historic scope of appeal rights in the deprivation context. Again, I submit that this is important and relevant because it was in this passage the Court was seeking to identify the underlying statutory purpose of these provisions, as well as the significance attributed by Parliament to the nature and role of the deprivation appeal in establishing a base level of procedural fairness. One can see from its reference to Parliament placing a high value of procedural fairness on section 45 that it considered that an important point, and it got the starting point wrong. We say it was mistaken on those points, and so its conclusions as to what was necessary to establish a procedurally fair process in terms of notification, timing, and the appeal system were therefore flawed. Well, moving on, in paragraph 28, the Court rejected the submission by the Secretary of State that it would be impossible, impractical, or pointless to afford an opportunity to make submissions at any stage. That was, of course, the second of the Bank-Mellat tests. That finding then led to the crux of the reasoning that's an issue in this case, at paragraph 29. And here, the Court accepted for the first time that the Secretary of State was entitled to exclude a right of prior representations on the basis of a risk of renunciation. Can I ask the Court just to read the whole of paragraph 29, and then I'll come back to make submissions. My Lords will see that the Court identifies there the limitation of the appeal to public law grounds, administrative law grounds, together with what it considered was a limitation on the evidence that could be considered by the FTT as the rationale towards the end of the paragraph for requiring post-decision representations to be invited and determined on their merits. It further justifies this on the basis that there would be no risk in that scenario of tipping off. Well, that, we say, is the third of the Court of Appeal's errors on this issue. It has misunderstood the scope of the appeal before the FTT, and indeed that is perhaps the most significant and serious of its errors. It flows from the first two I've identified, but it really strikes at the heart of what the Court of Appeal decided here. To make good that submission, first of all, I refer the court to the passage I've already shown, my lords, in N3 at paragraphs 36 and 37. That was expressly dealing with the scope of an appeal to the FTT, made it clear that the FTT could consider later evidence and would consider all the evidence that was provided before it. So that meets one of the points made by the court about the basis of the material to be provided on an appeal. Secondly, may I take this court to its decision in U3, where there's a particularly important passage on procedural fairness in my Lord Reid's decision. U3 is behind tab 97 of the hearing bundle and beginning at page 2174. Again, I don't need to go through the majority of this case. The passage I rely on begins at page 2198. And my lords will see, beginning at paragraph 80, this is a passage where my Lord Reid recalls paragraph 71 of Begum number 1, the well-known passage setting out the grounds on which SIAC may intervene on an appeal against a deprivation decision, the classic public law grounds, but also the fact that other legal principles may be applicable, for example, to human rights issues, and we now know also to statelessness. At paragraph 81, against that background, my Lord said this was not an exhaustive account of SIAC's role on an appeal under either of the two sections. The correct approach depended on the nature of the issue or issues which had to be determined. And of course, by this stage in U3, there's already been the further analysis on statelessness in N3, and then the further analysis in the earlier passages in U3 as well. There are issues which SIAC will determine by making findings of fact on a balance of probabilities, statelessness, other issues which cannot be determined in that way, even if SIAC has heard oral evidence. That will be the case in particular, where the determination of the issue does not depend on whether on a balance of probabilities a specific fact is true or not, but on whether on an overall assessment of the evidence bearing on the issue there is a proper basis for a discretionary decision to deprive a person of citizenship or to refuse the person entry clearance because of a risk to national security. And I pause there. That, of course, is exactly the issue that was concerning the Court of Appeal in paragraph 29, when it said it's not enough to say that appeal rights conferred by the Section 40A remedy the lack of a chance to make representations because of the inability to challenge the decision to find that deprivation would be conducive to the public good or the exercise of the discretion to deprive. So it was considering that discretionary issue. And my Lord then went on to say this, paragraph 82, in considering an issue of that nature, all the principles of administrative law were potentially relevant, except to the extent they were inconsistent with the statutory scheme. For example, in relation to deprivation decisions, procedural fairness is secured after the decision has been taken by means of the right of appeal to SIAC, rather than through the application of common law principles of procedural fairness to the Secretary of State's decision-making process at the time when the decision is taken. Well, my lords, we say that's absolutely on point here. The only distinction, the only possible distinction between the cases is that the current case involved an appeal to the FTT. But as my lords have already seen from the N3 case, the position of this court, the consistent position of this court, had been that the same approach in terms of an ability to take into account later evidence and determine the application on the basis of all the evidence before it has been consistently taken vis-à-vis the FTT as well. And going back as far as Begum 1, one can see that the analysis was that the statutory routes of appeal took similar approaches. Again, the passage at paragraph 40 I took the court to.
I mean, Mr Kiriko, of course, will be quite rightly able to say that what's said there was overture.
Yes.
I may have had in mind the decision in Begum 2. I can't remember.
Yes, well, my lord, quite. And Begum 2 is the next case I was going to come to, where that decision was absolutely squarely an issue, was definitely not overture, and permission to appeal refused to this court. So perhaps to adopt the words of Lord Hoffman in the Godmanchester case, there are obiter dicta and obiter dicta, and this obiter dicta has a context, and the context is the consistent approach that had been taken. With my Lord's observation in mind, can I then go to Begum number 2, because that probably is the point at which to show the court that decision. Begum number 2 is behind tab 71 of the appeal bundle. My Lord, I was having a debate with Ms Wakeman yesterday about whether to go to Begum number 2 or U3 first of all. I went to U3 on the basis it was a decision of this court, but my Lord is of course right, it's Begum that actually deals with it.
The page?
Page, sorry my Lord, begins at page, my Lord's there ahead of me, 1220 is Begum number 2. Again, to get the context, Begum number 1, as the court will recall, was the appeal, it was a joint set of 3 proceedings, but effectively on preliminary issues and entry clearance matters. After the appeal was dismissed, the matter went back to SIAC, which determined the substantive deprivation appeal. That case then went to the Court of Appeal, and that's the judgment here. Ms Begum advanced an argument that procedural fairness required her to have a right to prior representations. The background, I should say, is set by an earlier deprivation case called Al-Jeddah, which was a decision of SIAC. I think in 1 or 2 manifestations it made it as far as the House of Lords. But there was an earlier SIAC judgment which effectively found there was no right to prior representations. That's summarised, to give you the context, in paragraph 45 on page 1235. Just, if my Lords could read paragraph 45, I'll save you my voice for a moment. And essentially, my Lords, what you will see there is, and this is an accurate representation of the reasoning in Al-Jeddah, I don't need to go back to Al-Jeddah, there were 2 bases on which the Al-Jeddah assessment proceeded. One was that section 40 sub 5 was a complete procedural code. And the second was that in any event, the subject of a deprivation decision had a full appeal on the merits to SIAC. Now, unfortunate terminology, one might think, given what came next in Begum 1. And so, unsurprisingly, the argument was made in Begum 2 that one limb of the 2 limbs of Al-Jeddah's decision was no longer present because there's not full appeal on the merits. But that's when the Court of Appeal then, and SIAC before it, analysed very carefully the nature of the appeal that does exist and being one of a quite distinctive nature. The analysis begins on page 1250, at paragraph 103.
I mean, I think one must be a little bit careful. I mean, if you appeal to the Court of Appeal against the grant or refusal of an interim injunction,
yeah,
then the Court of Appeal exercises a limited jurisdiction, if you like. It will only interfere on well-recognised grounds.
Yes.
But that's not judicial review.
No.
It's an appeal.
Not quite.
And equally, if you have an appeal against a body which has particular expertise, then the appellate body is going to be cautious about finding that the first instance tribunal erred.
Yes.
But again, it is still an appeal.
My Lord, quite.
And something I was trying to explain in U3 was that there's nothing particularly odd about an appeal which it may be a straightforward appeal on an issue of fact, like, will I be rendered stateless?
Yes.
But if it's an appeal on an issue involving exercise of discretion, then that's going to affect the nature of the appellate exercise. And equally, if it's an appeal against a decision on a matter in which the decision maker has particular expertise, then again that's going to affect how the appellate body goes about its task.
My Lord, quite.
You know, it's nothing. There's nothing exceptional about this.
No, My Lord, with respect, we entirely agree, and it is perhaps...
If I might just add on that, I mean, my Lord's judgment in Begum 1, paragraph 69, which is at page 1292, is, as I read it, making this very point, that you have a full appeal, but that just gives rise to the question, well, what is the issue on the appeal? Exactly. On the basis of, or the grounds on which a full appeal might properly be allowed.
Well, quite.
Which, again, on my understanding, directly feeds through into my Lord's judgment in U3, indeed is the framework for that judgment.
My Lord, we respectfully agree, and indeed that was starting to become clear perhaps even before U3 and N3 in those passages I took the court to, which make the point that on appeal, there is a true appeal. And the first-tier tribunal, just like SIAC, can take account of evidence that's produced as part of the appeal process, some of which may postdate the decision in question, albeit it may cast light on events as they stood at the time of the decision, but is all there for the appeal tribunal or commission to take into account. The fact that you have an appeal doesn't tell you what the grounds are, and what the grounds are depends on the nature of the issue the appeal body has to determine.
And I think it was another point my Lord made in U3 that yes, new evidence can come in, but the Secretary of State is going to keep the decision under review throughout. And so, insofar as the Secretary, the proper issue is whether the Secretary of State has exercised their discretion on a proper basis. That's updated constantly through the appeal process, because the Secretary of State's officials on Carltona principles are reviewing it and either maintaining the decision on the base, having regard to even the new evidence which has been introduced, or accepting, no, we can't now maintain the decision and we'll concede the appeal.
Absolutely. And in that process, there's no need for new decisions or anything of that nature. It's simply part of the ordinary appeal process that any decision maker whose decision is under challenge, who is told, these are the grounds on which I'm going to challenge your decision, and here's some evidence to back up these legal submissions. If they're a sensible decision maker, they'll consider the evidence and the submissions, and they will either say, thank you very much, either here's a witness statement explaining why that's wrong, or here are some legal submissions in a skeleton argument explaining why that's wrong, and I'm going to continue to defend it. Or they will say, actually, that's a good point, I won't defend it on this ground, or I won't defend it at all. And there's nothing remotely new about that in the first-tier tribunal or SIAC. That's been going on for many years, as it has in all appeal tribunals. But it doesn't mean, and certainly Secretary of State's understanding of U3 is that it doesn't mean you have to produce a new decision all the time. It may well be, as my Lord indicates.
Well, just from memory, that was one of the points argued in U3, that the Secretary of State, there's new evidence, you better start all over again. And the answer to that was no, because the Secretary of State's officials will be looking at the new evidence as it comes in and either maintain the decision, in which case, effectively, that's a new decision. You don't need to go back to square one.
Yeah, exactly. And the way that's done in SIAC is you have what are usually termed National Security Statement 1 and National Security Statement 2. But those are statements. They are the statement usually of the national security witness, who will say, well, I've considered the evidence that's now being produced, and I still maintain the assessment I've made that this person is a threat to national security. It's no more than that. What one doesn't have to do is produce a completely new decision letter or anything of that nature. There's simply an assessment in the course of the appeal of the way that evidence is coming forward. And if that assessment is not carried out, then the Secretary of State is left with the assessment that exists at a particular time. And it may be that the new evidence that's produced undermines that assessment, but it will be ultimately for SIAC or the first-tier tribunal to make that assessment on its own. There's no automatic invalidation of the decision under appeal, because that hasn't been done.
Can you just remind me, what witnesses were called on behalf of the Secretary of State before the first-tier tribunal?
So in the first-tier tribunal, there were no witnesses on behalf of the Secretary of State. And again, that would be ordinary in a case of this nature. So in SIAC, you would routinely have, if it was a national security case, a national security witness called on behalf of the Secretary of State, who would be usually a security service officer, depending on the nature of the case. They would speak to the national security assessment that had been made. As indicated in my exchange with Lord Sales, if it was necessary. It might not be necessary in a particular case because the evidence produced might be very insubstantial. But if necessary, they can produce additional statements which effectively update their assessment, but they're not new decisions. Similarly, in a case based on serious organised crime, in recent cases, the Home Secretary has called a witness on behalf of the National Crime Agency, so there would be an NCA officer fulfilling the same function as a security service witness in a national security case. And they would be speaking often to intelligence assessments, secret evidence, matters of that nature. Very, very similar to the national security process, but serious organised crime, and therefore using a specialist agency for that purpose. Here, because the case was in the FTT, the usual position is that the Secretary of State won't call evidence, because cases that go to the FTT in deprivation work tend to involve a criminal conviction. They don't have to, but a criminal conviction would be a very easy way, in principle, of proving the serious organised crime in question. If you don't have a criminal conviction, but you still have allegations of involvement in serious organised crime or national security activity, then in reality, one is going to need closed evidence to make good those allegations, because it will be intelligence, which is very likely to be highly sensitive, either because it's from CHIS reporting or it's intercept material or whatever it may be. But that would be that's the reason why one doesn't have a witness in the FTT.
Should the evidence of the further risk of reoffending have been admitted before the FTT?
Yes, it could have been. It
should have been or could have been?
I just want to check whether I should say was. It was admitted, yes. So it was admitted before the FTT.
Excluded.
Sorry.
I thought it was excluded.
My understanding was it was admitted. May I just confirm this.
Yeah, that's totally right.
My Lord is right. It was excluded. My little friend reminds me quite rightly, it was excluded. So I had in mind something different. I understand the point now made. Yeah. That was excluded. In principle, it could have been admitted, but of course, the Secretary of State, or rather the tribunal, also had the assessment of the NCA as to risk of reoffending. So it wasn't that it was without evidence. And indeed, there's no ground of appeal now on the basis that that was a particular flaw in the tribunal's approach or anything of that nature. But in principle, certainly given the approach of this call in U3 and N3, it could have been possible to reduce that evidence. The focus would be in looking at the position at the time of the decision of the question, but it would certainly be possible to admit that evidence. My Lords, I was going then to Begum number 2. I've shown you the Al-Jeddah passage, and then the point is picked up at page 1250, paragraph 103 under the heading Ground 4A due process.
Sorry, paragraph?
Paragraph 103, my Lord, 103.
1250.
1250, exactly. I won't go through all of that. You'll see the contours of the argument are set out. At 107, you'll see SIAC step back from what it had said in an earlier case called B4 about there being a general rule that there was no need to make prior representations. But it said the Court of Appeal then concluded in 107, in our judgment, the general rule is apt to notify a person a broader intention to remove their citizenship could obviously act as an encouragement to return preemptively, and then like SIAC, we do not consider the fact that some deprivation decisions involve persons already in the UK or are made under subsection 3 makes any difference to the basic analysis. So it's an analysis which applies across the board. Then there's reference to the Al-Jeddah decision, and then at 109, in the present case, SIAC agreed that subsection 5 contained an exhaustive procedural code, but was not satisfied that that was sufficient in and of itself to exclude a right of representation. In the light of Bank Mellat, that might be so if section 40 were to be construed in isolation, but to do so underrates the distinctive nature of an appeal to SIAC. So this is the passage I wanted to show the courts. The Court of Appeal in Begum was absolutely aware of the arguments about the nature of the appeal and how far it could go. It directed itself then to U3 as it stood at the time in the Court of Appeal. It says section 40 must be read alongside the SIAC appeal right. It refers to what was said to be the full merits appeal. It then says Begum in the Supreme Court lays down the appeal to SIAC is not a full merits appeal. However, what is clear is that the Act affords an appellate merits review and is not merely a judicial review exercise. So, my lord, there can be no suggestion that this Court of Appeal, that the Court of Appeal in Begum 2 fell into the error of saying, well, it's all just judicial review. Absolutely not. So much can be seen from the Begum Supreme Court decision itself, paragraph 65 and 69, which my Lord Sales has just referred to, exactly that point, and U3 in the Court of Appeal. They then refer to paragraph 171 of U3. That's one of the passages that was undisturbed in this court's decision. And then this at paragraph 112. The existence and distinctive nature of this right of appeal and the risk of preemptive action by the appellant if prior notice is given remain, in our view, compelling reasons to construe section 40 sub 5 as excluding the right of prior consultation before a deprivation decision is made on the grounds of national security, as was held in Al-Jeddah. So the finding is that there is an implied exclusion of the right to make prior representations. One doesn't even get to the impractical, impossible, and all the rest of it test in the second part of Bank Malat. There's therefore merit in the Secretary of State's Respondent's notice on this point. On the basis of the open arguments, we agree that SIAC fell into error in concluding that Begum was entitled as a matter of procedural fairness to make prior reps before the Secretary of State took the decision. Of course, Ms Begum, it should be recalled, was in a particularly acute position because she was in, well, at the time of Begum 2, in the Al-Roj camp, had previously been in the Al-Hal camp in northern Syria, being held in conditions akin to detention by, well, in camps run by the Syrian Defence Forces. So there was no realistic prospect she could come back, and yet the statement is one of principle, and it's one of principle encompassing the full gamut of cases, including people here who run the risk of renunciation and cases under sub 3 as well, as one sees from 107.
Very strictly, again, is this not obiter? You suggested that this was ratio, but I'm just looking at paragraph 114 where they say it makes no difference to the outcome.
Well, my lord, that is true, but even if, and this was the finding of the Court of Appeal in another deprivation case, D5 to 7 and C9 that we've referred to, even if this were obiter, and we say these are perhaps better viewed as alternative ratios, but even if it's obiter, it is a ruling reached after full argument on the point, on a point of principle, by an extremely senior Court of Appeal. It involved the Lady Chief Justice, Lord Justice Bean and Lady Justice Whipple. So both senior and also, through Lord Justice Bean in particular, with considerable experience of this sector of work. So again, there's obiter dicta and obiter dicta. If it is obiter, it's extremely persuasive. And it was taken forward as a matter of principle then before this court on appeal. And it was raised as ground 2 of the appeal to this court. We have in the bundle, at tab 108, the refusal of permission to appeal order, which is an order with reasons, unusually. Can I just ask the court to turn that up? The relevant page is page 2454.
245?
2454.
Thank you.
Yes, this is very unusual because the case was one of such public interest that very unusually the panel gave quite full reasons for its decision.
My lord, yes, quite. And my lord, those reasons included on page 2454, under ground 2, you'll see the appellant maintains she had a common law right to make representations to the Secretary of State before the deprivation decision was taken. The panel agrees with the Court of Appeal that a right to make representations before a deprivation decision is made would be liable to undermine the effectiveness of such a decision in cases concerned with national security and is therefore impliedly excluded. No reliance there on the alternative point that might be said to make this obiter. As I say, perhaps the better view, particularly given the way it's put on appeal, is that there are alternative ratios there. So, having started with U3, I wish I'd begun with Begum 2. That's the answer to my Lord's point about Begum. That is where that is considered in some detail. And even, therefore, if the U3 analysis of procedural fairness is strictly obiter on that point. It is again an observation made, we say, completely consistently with all the other observations in the consistent case law and completely reflecting this court's decision in refusing permission to appeal in Begum against the background of the very detailed consideration in Begum 2 by the Court of Appeal. My Lord, I've already made the submission that there's no basis to distinguish between SIAC and the FTT on this ground. I won't go through those submissions again. I've just got one eye on the clock. I've given you my submissions on Begum number 2, and I've already made my submissions on U3. We say for all those reasons, this is perhaps the most significant of the 3 errors that the Court of Appeal committed in these particular passages. It goes to the very heart of the court's reasoning in finding that there was a need for procedural fairness requiring post-decision representations. That's what then led to the decision at paragraph 30 that both the deprivation decision, the notice and the order had to be quashed. I just add this. The court at paragraph 31 said that the Secretary of State has simply overridden the obligations of fairness in the interests of expediency. With respect, that is not a fair or accurate summary of the practice that was being adopted post-Rochdale. And if that is what the court was referring to there, that practice was adopted not in the interests of mere expediency, but in order to protect the integrity of the statutory process. One of the parts of the analysis in Begum number 2 in the Court of Appeal I didn't take you to was the court's analysis of when you can impliedly exclude something by reference to cases like Black in this court. And they said one of the reasons you can do that here is because the whole statutory process would be frustrated. So it was a very important reason that the Secretary of State was adopting that here. Well, very briefly on the fourth point, the fourth error. This relates to the fact of Mr Kolicaj's case, and this is the point about there having been a representation made in the ministerial submission that representations would be considered. My Lords, I've taken you to the documents that are based on, that make up that particular point. So the NCA submission, the ministerial submission itself, and Annex C. I don't need to go back to them. Can I just make these 4 short points? First of all, the reference to making submissions has to be seen through the prism of the NCA recommendation, which said that will be done through the appeal process. That was right, and that was the document, the prime document to which the Secretary of State was being directed. Secondly, most of the incidents where representations are referred to relate to deportation or deprivation. Thirdly, insofar as there were limited references to deprivation, again, one goes back to the NCA context, and there was no suggestion that the Secretary of State was being asked to delay her decision. And fourthly, of course, this isn't a case where anything was being said to Mr Kolicaj himself, which could give rise, for example, to anything in the nature of a legitimate expectation or anything of that nature.
I'm sorry, sorry, the fourth submission again.
The fourth submission was that the only documents in which anything was said about further representations being made were not documents that were directed to Mr Kolicaj. He wasn't, in other words, given any sort of assurance that could found, for example, a legitimate expectation argument or anything of that nature.
Thank you.
My Lord, I've already made a submission about principle based on the Balajagari paragraph 60 passage, which you have in the Court of Appeal's judgment. I say precisely those reasons for not according a right to post-decision representations arise here. And I say the Court of Appeal did err in the ways we've suggested in those 4 ways on ground 1. Those are my submissions on ground 1, unless I can assist further on that point. I should have said there was one additional element I was going to cover, which was the distinction between the rules in the FTT and SIAC. Can I do that very, very briefly? I should indicate I'm coming to the end of my time. Mr Kolicaj has very kindly indicated that he is content for me to continue for a few minutes if I take it off my reply. Would the court be content for me to do that?
Yes, certainly.
I'm very grateful to Mr Kolicaj for his assistance in that. Well, look, I'll take it, though, as briefly as I can. The only passages I need to take you to in the relevant rules, and one case, I think, are first of all in the first tier tribunal rules, Rule 24 to begin with. That's behind tab 56. And it's at page 784. So this is the rule on responses from the Secretary of State to an appeal. It says in other cases, that's in non-entry clearance cases, effectively. You'll see that with the exception of the entry clearance cases and the cases to which Rule 23 applies, where the Secretary of State is provided with a copy of a notice of appeal, she must provide the tribunal with, and I'll just focus on these points, A, the notice of the decision to which the notice of appeal relates and any other document the respondent provided to the appellant giving reasons for that decision. And then B and C wouldn't be relevant here. They would be relevant in cases where there was an underlying application and an interview. But then D, any other unpublished document which is referred to in a document mentioned in subparagraph A or relied on by the respondent. What I say about that is that those particular, the combination of those features mean that everything on which the Secretary of State relies in a deprivation decision case would be disclosed to an appellant in the first tier tribunal. There is no closed procedure in the FTT, and so there's no need to consider mechanisms for protecting the sort of material that would be considered in those sorts of procedure. The appellant gets to see everything on which the Secretary of State is relying. Nothing is held back. In addition, you have at Rule 24A a provision then for further steps. This is at page 786. And you'll see there that if the appellant is represented upon the respondent complying with the preceding rules, the appellant must provide the tribunal with appeal skeleton arguments and copies of the evidence relied on in the appeal skeleton arguments, if not contained in the documents provided by the respondent. You already have the point from Began number 1 that there are no rules specifically on the sorts of matters that may or may not be considered. So in the context of a deprivation appeal. So the appellant in a deprivation appeal is given effectively a very wide ambit here to produce the evidence they wish to rely on to make good their case. And that, of course, would have to be so in light of paragraphs 36 and 37 now of N3 and the other passages I've taken you to. There is then a further provision in subparagraph 3 for the respondent to respond with a written statement which complies with any relevant practice about whether the respondent opposes all or part of the appellant's case, and if so, the grounds of opposition. That's what you'll have seen referred to by reference to the practice statement terminology as a meaningful review in the learned friend's written case. That's what the practice statement says. But again, the core point here is the rules now provide, and this rule came into force just after the appeal in this case, but it now provides specifically for the tribunal to be updated effectively by the Secretary of State as to the position being taken on the appeal. So the Secretary of State will update the tribunal to say, well, having seen the evidence, we maintain the appeal. And it may be as simple as that. Or it may be we maintain it on these limited grounds, or it may be the appeal is conceded. It could be done in a number of different ways, depending on what evidence the Secretary of State was facing. There's no specific one-size-fits-all approach to that, but it allows for that to be done. In those circumstances, my ultimate submission is, one that I headlined earlier on, there is no need for anything further by way of detailed procedural rules. One has all the procedure one needs to bring out from the Secretary of State the relevant decision-making documents and to allow the appellant an opportunity to respond to that with the evidence that the appellant wishes to draw to the tribunal's attention. All the detailed provisions of, for example, Rule 10 and 10A in the SIAC procedure rules that you've seen in the written cases are not needed here because you don't need the additional exculpatory reviews in circumstances where you're not holding material back from an appellant. The reason why the SIAC rules make detailed provision for exculpatory reviews is because an appellant in SIAC is effectively shooting in the dark. They don't know the target they have to hit. They're given very often very, very bare reasons for a decision that's taken against them, and much of the detailed argument takes place in close. So one can understand why the SIAC rules require the Secretary of State to investigate the exculpatory position in such a detailed way. There's just one case I should also take my lords to on this point, which is useful in setting out procedure in the first-tier tribunal, and it's a case we've set out in the supplemental bundle called NIMO. It's a case in the tribunal itself, in the upper tribunal, obviously not binding in this court, but it sets out the procedure that's adopted. Could I ask the court to turn that up? Within the supplemental bundle, it's behind tab 11. It begins at page 125. And the discussion of relevance begins at page 133. You'll see at paragraph 21, the authorities, it said, were usefully analysed by the upper tribunal in a case called CM. That case went to the Court of Appeal, and you have the Court of Appeal's judgment in the previous tab, tab 10, beginning at page 110. Skipping over the quotation from the upper tribunal's decision there, one sees the case of Karouche number 1 cited about level with the second hole punch. And you'll see the quotation there from Lord Wolfe, 4 lines in. The obligation of the Secretary of State cannot be put higher than that he must not knowingly mislead. Before the Secretary of State could be said to be in that position, he must know or ought to know that the material which is said he should have disclosed materially detracts from what it was that he has relied on. So this is a passage dealing with the extent of the Secretary of State's disclosure obligations in the tribunal. Over the page, you'll see at paragraph 23, the upper tribunal appears to have equated judicial review proceedings with a statutory immigration appeal, but the two types of litigation are distinct. No legitimate reason to import into immigration appeals a duty of candour. Basic reason it's necessary and inappropriate to do so is set out in the skeleton argument, and if I can ask the court to read on in the rest of 24. My lords, just 2 further passages. At 26, to put that another way, in an immigration appeal, the reasons for the respondent's decision are merely the starting point of an independent judicial process. Once this point is grasped, it can readily be seen as no justification for a rigid requirement to serve the particular document in question. Well, I pause there. That's very similar to the analysis in the Supreme Court cases that I've been taking the court to this morning. It's the start of the process. But the jurisdiction is operated independently. It's not just a judicial review. And then over the page at 35, at paragraph 35, the duty not to mislead will require the respondent to disclose that particular form where there's something in it which could materially assist the appellant, but which is not mentioned in the respondent's decision or in the records of interview. So again, the approach to not misleading in the tribunal is actually very close to a duty of candour and certainly sufficient to protect the sorts of interests at stake in the tribunal process in decisions of this kind. My lord, that's what I wanted to say about the procedural rules, and that, unless I can assist further, concludes my submissions on ground 1. I can be much briefer on ground 2, and again, with an eye to the clock, I will be. I make 2 core submissions on this ground. The first submission is that the court's decision to quash the deprivation order as well as the deprivation decision is inconsistent with this court's decision in N3. The reason for that can be seen from 2 passages in N3. Can I just take the court back to those passages? N3 is behind tab 88. The first passage is at page 1801. It's Firstly, paragraph 45, which begins at the bottom of page 1800. At the top of page 1801, you will see that this court, my Lords, Lord Sales and Lord Stevens, say this: is no requirement on the Secretary of State to await the response from the person concerned to the written notice before making a deprivation order. Sorry, you've already had that passage. It's actually paragraph 48 that I wanted to take you to. Sixthly, the person concerned has a right of appeal against a deprivation decision, although not against the order itself. This is a further indication in the context of an appeal, no distinctions to be drawn between the decision and the order which implements it. The appeal against a deprivation decision necessarily involves an appeal against the grounds on which the order is made. If the order is made under sub 2, then it's common ground the appellate body determines for itself whether the order will make the person concerned stateless. That then leads into the analysis at page 1812 and 1813. And at page 1812, paragraph 90, 3 lines above letter G, you have this: once SIAC determines that recognition of the validity of the deprivation order would render the individual stateless, it allows the appeal against it. And you see at the end of that passage, the order is to be treated as having no effect. And then over the page, 3 lines above letter C, in paragraph 92, once SIAC makes its determination that the deprivation order would make an individual stateless and accordingly allows the appeal against it, nothing more is required to be done. The Secretary of State is simply bound by the determination for all purposes. And at 93, as a matter of good practice and for good order, we consider the Secretary of State should formally withdraw the deprivation order as from the date of the SIAC or tribunal order to minimise the risk of confusion. So that's what's expected in terms of remedy.
Well, the position was somewhat different because SIAC didn't make any orders, and therefore you had to work out what the effect was, and which is a different question from could SIAC make an order?
Yes.
So why not quash the decision?
So,
and why not, if the decision is quashed, why doesn't that also affect the order?
So the ordinary position would be that the decision wasn't quashed, the appeal would simply be allowed, because going back again to the point made in paragraphs 38 and 40 of Begum number 1, that there haven't ever been any provisions made with respect to deprivation appeals to give SIAC or the FTT that power to quash. So the ordinary position is that it's simply giving effect to...
It couldn't have a continuing effect in the intervening period if you quashed it, yeah.
Exactly. So that's why, in my respectful submission, the proper approach is that you simply allow the appeal, and then, for understandable reasons, this court said, as a matter of good order, you withdraw the order, but you can't quash it. And of course, the Court of Appeal on appeal only has the powers of the lower court. That's CPR 52.20. So there is no power, and that's a more fundamental point, to actually quash the order in a case like this. There is also the fact that...
But I mean, it's a slightly curious submission you're making. The reason you're saying there's no power to quash the order is because the court has achieved, or the tribunal has achieved, a more fundamental effect by allowing the appeal.
Yes.
So you couldn't possibly act on the basis of the order.
My Lord, I fully accept that, and of course that ultimately is the conclusion in N3. You couldn't act on the basis of the order to say that somebody had been not British in the intervening period. Right. But there was a utility of the order in the interim for allowing immigration enforcement action to continue. That was the conclusion in N3. Now, this is a case where there was a deportation decision made in the interim. And so here we say there was a utility in having the order in place in that way. But ultimately, if there's no power to quash the order, there is no power to quash the order. But the submission I'm not making is that there is, in the event of a successful appeal, any further continuing effect of the order. I accept that's not the case.
Right, okay.
My Lord, I'd only add this on ground 2 before I close. One of the points that Mr Kolicaj entirely fairly raises as a matter of fact, and you'll have seen how we've dealt with this in our written case, is that the wording for the order in question came from the counsel then instructed by the Secretary of State. And so effectively that was the suggestion for the draft order that was made. What I would say is, although that is correct, the Court of Appeal's decision itself talked about quashing the order. That is what is said in paragraph 30 and elsewhere. So that wording was simply giving effect to what the Court of Appeal appeared to be saying at the time. But I say no more about that in the circumstances. My Lords, unless I can assist further, those would be my submissions on ground 2. I'm sorry I've gone over my allotted time. I'm extremely grateful to my learned friend for giving me a bit of my reply in advance, as it were.
Thank you very much, Mr Blundell.
Very grateful.
Mr Kiriko.
My Lords, thank you very much for that. So I would like to start by trying to identify some of the points which are not in dispute between us, and also perhaps indicating some of the points which are and which may not be clear. So we say that the starting point for an assessment of the importance of procedural fairness in a case like this is the fundamental importance of a person's status as a British citizen. That's reaffirmed by your Lordships in N3 earlier this year. The status of citizenship is a fundamental status at common law, gives the common law right of abode. That right of abode is a right of fundamental importance, and therefore a decision to remove it from someone is a decision which one would expect to be protected with particular assiduity. The second thing about this case is that, and it's maybe not very obvious from the authorities before you, is that this litigation has played catch-up throughout with subsequent decisions of this court. And
they've been coming at us thick and fast.
My Lord, yes, absolutely. And they were coming at this litigation. So just by way of example, and this is something that I think none of us realised in the Court of Appeal, when the initial decision was made in this case, and when the initial advices were given to the Secretary of State, your Lordships had not yet decided Begum number 1. So when the Secretary of State was advised that that Mr Kolicaj would have the opportunity to make further submissions, that was at a time when everyone believed that the statutory appeal from this decision would be a full appeal, an appeal where the First Tier Tribunal sat in the shoes of the Secretary of State. Very shortly after this decision was taken, your Lordships handed down the decision in Begum, which corrected that understanding of the functions and jurisdiction of the First Tier Tribunal, or of SIAC. When this case came before the First Tier Tribunal, the guidance which the First Tier Tribunal was following was a case called Chicheri, which is in the bundle. I'll take you to that a little bit later, but that was the upper tribunal's first engagement with the principles that your Lordship had established in Begum number 1. And it, we say, led the First Tier Tribunal at the time of Mr Kolicaj's appeal to take a narrower view of its jurisdiction than we now understand to have been right. Between the First Tier Tribunal's decision and the upper tribunal's decision, I should say that as I think my learned friend Mr Blundell just pointed out to you, Rule 24A of the First Tier Tribunal procedure rules, of the Tribunal procedure rules, came out the day after the First Tier Tribunal appeal in this case. So the quite important provisions for review, which are now in the First Tier Tribunal procedure rules, were not in place when Mr Kolicaj had his appeal. Then between the First Tier Tribunal's decision and the upper tribunal's decision, the upper tribunal handed down a further decision seeking to apply the Begum guidance, and that was the case of Chimi. And that's, I'll take you to it later, but it's at tab 75 of the bundle, and the important provisions are in the head note. And at that time, the upper tribunal... Sorry, I'm so sorry, it's page 1343. Thank you. My Lord, sorry. And the head note is taken again from paragraph 75, which is on page 1368. And what's important in that decision of the upper tribunal is that the upper tribunal at that point considered that there were 3 stages to a statutory appeal from a deprivation decision. The first stage was to review the question whether the Secretary of State had rationally established or had lawfully established that deprivation was conducive to the public good. So that's the first of the two elements of the statutory test or the statutory procedure. The second stage was to determine whether the Secretary of State had rationally or had lawfully exercised her discretion. But importantly, at both of those two stages, the tribunal was said to be confined to the evidence which had been before the Secretary of State. There was no question there of evidence being admitted for the purposes of determining whether the statutory criteria had been met. The tribunal was then to move on to any human rights elements, but in moving on to, and at that stage was entitled to consider up-to-date evidence, but could not revisit the findings made about conduciveness and about the exercise of discretion. So there was a strange hybrid situation or hybrid environment for the tribunal to operate in, where it had to decide the public interest side of any proportionality or any Article 8 exercise.
Is this the reason that the FTT, in our case, excluded the material on the probation report?
My Lord, Chimi had not yet been decided. Chicheri was the case which is operative. Chicheri is not clear, but certainly the First Tribunal, I'll take your lordships to this in a moment, but was invited not to have regard to material which post-dated the decision, and it didn't.
Right.
But yes, so Chimi wasn't yet in place. Chicheri, which certainly didn't inform the First Tribunal that it could admit further evidence for the purposes of the conduciveness and discretion tests. That was the operative decision at that time. And my lords, we then, when this case came to the Court of Appeal, the Court of Appeal didn't have the benefit of the lordships' judgments in N3 or in U3. It had the benefit of the Court of Appeal's judgment in U3, but the clear understanding both of the consequences of an allowed appeal in N3 and of the nature of the further explanation of the nature of the process before the tribunal, which your lordships gave in U3, just wasn't before the Court of Appeal. And we would accept that as a result of that, the Court of Appeal has made a couple of mistakes. So we accept that paragraph 27 of the Court of Appeal contains a misreading of the statutory purpose. So when I'll just turn it up again. So that's the paragraph you were taken to by Mr. Brundle, and it's tab 5, page 113, paragraph 27. And we accept that the purpose of section 40, subparagraph 5, is not to enable the person who's the subject of a decision to make a deprivation order to bring an effective appeal before the order is made. We say that reading the Court of Appeal's judgment as a whole and fairly, this is more likely to be a problem with expression rather than of understanding, because it's very clear throughout, even in the same paragraph, it's clear that the Court of Appeal recognised that the power exists to make an order without awaiting an appeal. It's the very next sentence of paragraph 27. Well, Justice Edith says that provision has been applied differently in section 42 cases. He certainly doesn't suggest it's been applied unlawfully. Though he plainly understands, and the Court of Appeal plainly understands, that section 45 doesn't prohibit the making of an order before an appeal has been brought. And similarly, at paragraph 29 on page 114 of the judgment, Lord Justice Edis expressly accepts that it's legitimate in Section 42 cases to operate a system in which the Secretary of State informs the person affected of the decision only after it's made and because of the risk of renunciation of the other nationality. He wouldn't have said that if he thought that the function of the purpose of Section 45 is to prevent that from happening. And that's a theme which runs through the judgment. It's clear also that Lord Justice Underhill understands that sorry, nothing in the statute prohibits an order being made before a person has been given any opportunity to make representations about it, and certainly before a person's had the opportunity to appeal against the decision.
You presumably also accept in paragraph 27 that the Court of Appeal were not right to say that at the time of the 1981 Act there was understood to be an appeal on the merits. So,
on that point, I don't accept that, and it's not clear that that's correct. So I'm just going to come to that next. I'm so sorry. The same panel of the Court of Appeal sat on 3 deprivation appeals within a fortnight last December, and one of the other cases which they heard is Chowdhury, and you'll find that in your bundles, my lords. At tabs 74, page 1334. And so that's the case where the Court of Appeal, in the judgment of Lord Justice Dingemans, conducted a more detailed review of the history of the relevant rules and of the acts. And the court's conclusion there was that the fact that the inquiry could call for evidence and could call for an explanation from the Secretary of State rather than start with the decision of the Secretary of State suggested...
You're reading where from?
My lords, I'm so sorry. It's page 1334, paragraph 29, bottom half of the paragraph.
Thank you.
So the conclusion of the Court of Appeal was that the various provisions of those rules suggested that the inquiry had at that time a de novo fact-finding function and was not restricted to a review only of the Secretary of State's decision. My lords, I do accept that there's no provision in those rules to explain what the consequences are of the inquiry.
Right, but also it's not an appeal, though, is it?
It's not an appeal, my lord, no. And so I accept that what is said in paragraph 27 about of the Court of Appeal's judgment about that is inaccurate, but whether that goes to any...
It's quite interesting to see the history. It goes, as Blundell said earlier, it goes back to provision in the 1914 Act concerned with the revocation of certificates of naturalisation.
My lords, yes, and from memory it was...
inquiry procedure.
So, yes, and from memory it was the lack of clarity or the lack of independent status of that inquiry which was criticised in Chahal, which resulted in SIAC. I may be misremembering, but
yes, you're right. The Strasbourg court, I think, were impressed by what they thought happened in Canada and suggested what they thought happened in Canada might be copied in the UK. And Canadian judges tell us that, in fact, it's not the same.
But in fact, I think in Chahal, it wasn't so much uncertainty about the status of the Committee of Inquiry report. It was more the reliance on secret evidence that wasn't available.
So it was the reliance on secret... my lord, absolutely, yes, sorry, you're right. You're absolutely right.
That's what then leads
in the context of Article 5, yes. Yeah. In the context of Article 5, yes, sorry, that's absolutely right. So... But our overriding submission about both of those errors, which the which the Court of Appeal has fallen into, is that they don't matter, or they don't have any bearing on the question which both the Court of Appeal decided and on which we invite your lordships to uphold the Court of Appeal, which is the question of fairness. What paragraph 27 is there for is simply to explain why the Court of Appeal concluded that Parliament attached a particular weight to procedural fairness in cases such as this. And my submission would simply be whether Parliament has attached particular weight to procedural fairness or not. Particular weight should be attached to it, and the courts would attach and do attach particular weight to procedural fairness to the extent possible, subject to the Bank-Mellat exceptions, in the context where the Secretary of State is exercising a discretionary power to remove such an important right as the right of abode. So, although the Court of Appeal may have gone wrong in its route, it's arrived at the right place, which is that a high weight or high value is placed on procedural fairness, and nothing in the. So while the Court of Appeal may have been wrong to find elements in the Act, or those particular elements in the Act which demonstrate that high value, there's certainly nothing in the Act which suggests that
procedural fairness just provided by the appeal procedure.
My Lord,
isn't procedural fairness provided by the appeal procedure?
So, my Lord, yes. So, for the purposes of issue 1, we assume, and this is the next common ground, although it's common ground as a matter of presumption, we presume that the Secretary of State is entitled, in a case like this one, to give no prior notice of a decision. And the question then is simply what is necessary after the decision in order to maintain or protect fairness. And we say that we don't, for 1 minute, suggest that the reasoning of your lordships in U3 or of Lady Chief Justice in Begum number 2, we don't dispute that for a minute that those are strongly persuasive, with respect, strongly persuasive arguments, and we don't seek to go behind them. But what we'd say is that the distinctive appeal, which is referred to in Begum number 2, and the statutory context, which is referred to in U3, is the statutory context of appeals to SIAC. So it's section 40 and 40A of the British Nationality Act 1981, together with the appeal right to SIAC, the SIAC procedure rules and SIAC procedures as they're described in U3 and in Begum number 2 and in the sequence of decisions of the higher courts since Begum number 1. So what we say is the statutory context is not simply section 40 brackets 2, it's section 42 plus the whole of the appellate regime in SIAC as it operates in practice and as it's described. And certainly for these purposes we accept that if there was an appeal structure which was equivalent to that which is available in SIAC, then that would be an answer to the concerns about a lack of prior representation. That's the way in which we've argued the case, on that assumption, on issue 1. So assuming that the Secretary of State has demonstrated that there is a real risk of renunciation of a second nationality and therefore the frustration of the purposes of deprivation, assuming the Secretary of State has demonstrated that, then we accept that an appeal which has all of the protections which are in SIAC provides the fairness, provides the necessary level of fairness.
But I mean, why doesn't this appeal have equivalent protections to what's available in SIAC?
So that's what I need to persuade your lordship. So what we say is that firstly, nature of the appellate regime in SIAC is not matched in the FTT.
Well, isn't the starting point the statutory provision? The statutory provision is exactly the same.
The statutory, my lord, absolutely. So we accept that a Section 40, an appeal from a Section 42 decision is an appeal on exactly the same grounds, which should have the same protections, whether it goes to SIAC or to the First Tier Tribunal. But what we say is that it doesn't, as a matter of fact, and it didn't, as a matter of fact, in this case.
And I'm sorry for pressing you on it. What part of the case that the Secretary of State was making was your client unaware of? And what were the facts that your client wished to establish?
So the parts of the case which Mr. Kolicaj was not aware of were my lord, I think I need to just go through the order in which matters were provided. But the short answer is he wasn't made aware until very shortly before the appeal of the ministerial submission, number one. He wasn't then made aware until even more shortly before the appeal of the what we call policy, but the advice to the Secretary of State about the circumstances in which a deprivation decision should be taken or not taken.
But did he have sufficient time in that short period in order to make his case?
Well, it wouldn't have made any difference because the Secretary of State didn't review. So the difficult, my lord, so the difficulty, what Mr. Kolicaj complains of is firstly that there was no process which enabled him to have access to what we say was necessary material, whether under the First Tier Tribunal procedure rules or under SIAC. There was no provision for review of exculpatory material. Sorry.
I'm sorry. I thought you told us that he did have all the materials that you've just referred to before the appeal.
So those were only provided as a result of a series of specific requests for disclosure, and the Secretary of State's view was that they were not disclosed, that there was no requirement that they be disclosed. More significantly,
but they were disclosed.
They were disclosed, but the difficulty then was that there was no opportunity provided for him to address the Secretary of State on them.
Well, so you could do so during the appeal process. You can say, here I've now got all the documents. These are the points I want to make in relation to these documents. This is the evidence I'm going to give. And here's my witness statement.
So, but it's necessary to look at what the issues were. There were no disputes of fact. So there was no need for him to give factual evidence. The evidence, my lord, you referred to the trips to Albania. They are in the sentencing remarks. They were already before they're in the sentencing remarks, and they were already before the Secretary of State at the time of the decision and before the tribunal. What was excluded was Mr. Kolicaj's response. So he, shortly after being released from prison, obtained the probation. Well, the probation assessed him, and there was a report which assessed him as posing a low risk of reoffending. And I'll come back to the reasons why that's important, maybe after the short adjournment. But what he did not know until very shortly before the hearing was that the Secretary of State had a policy which restricted the apparently very wide discretion under which she made deprivation orders.
Right. I'm so sorry to pick you up, but you said Mr. Kolicaj had no opportunity to address those materials, which includes the policy. But I think my lord was putting to you, he can address them in the appeal. And isn't that right? But he's got them, and the appeal's the place where you have the argument about their significance.
But where the First Tier Tribunal is declining to admit any evidence which wasn't already before the Secretary of State, that.
Well, I mean, that may be right and may be wrong, but this appeal seeks to, well, your response to this appeal seeks to uphold the Court of Appeal's tentative edifice of an intermediate process, rather than simply says, well, the FTT were wrong to exclude that evidence.
So what we say was necessary was that there be a procedure in place whereby an appellant puts further material to the Secretary of State. The Secretary of State conducts a review, as she does in SIAC. There is no review. No review took place at any stage in these.
The Secretary of State was represented during the course of the hearing, and presumably counsel was taking instructions from the Secretary of State in continuing to oppose the application.
But so the kind of review, maybe that's not been very helpful that I've tried to identify issues between us and not rather than taking you through the case, because I'm straying rather into other things. But what we say is that what is considered, what is imagined as a review, what the kind of review which happens in SIAC and which is described in U3 by your lordships is a review by an officer of the Secretary of State acting in accordance with Cartona principles.
Right, but that's only if new material is introduced on the appeal.
Yes.
Which the Secretary of State hadn't considered before.
Yes.
Here, there's no new material.
Well,
I mean, we start off with the conviction. The Secretary of State decides on the basis of the conviction. Mr. Kolicaj doesn't give evidence himself.
So,
if he had given evidence himself, then those representing the Secretary of State in the appeal would have taken instructions on that to see if it changed the Secretary of State's view. Thus far, it would be exactly the same as what happens in SIAC.
So, my Lord, there are two things. The Secretary of State, three things. Firstly, the Secretary of State didn't take a decision based solely on the previous conviction. She also took a decision in which she expressly refers to a risk of reoffending.
Right.
The appellant before the first tier tribunal then adduced evidence which sought to rebut that conclusion that he posed a risk of reoffending.
Right. This is the probation report.
This is the probation report, yes.
Right.
The Secretary of State at no point considered it was unnecessary to review it, and didn't review her decision in light of that evidence. She didn't dispute it, but she didn't review her decision in light of it.
Right.
So what would have happened in SIAC, which was that material would have led to a review, didn't.
Well, not if it was excluded by SIAC, as it was excluded by the FTT here.
Well, it was excluded by the FTT here on the wrong understanding that evidence that post-dated the decision couldn't be considered by the FTT.
Right, that I understand. But if SIAC had done the same, it wouldn't have been reconsidered for the same reason. That it's the distinction between what you're saying, SIAC, is the position in SIAC and the position in the FTT that I'm struggling to understand.
My Lord, so it's the position in SIAC proceedings. SIAC proceedings provide for the Secretary of State to conduct a review. So it's not SIAC who's doing the review, it's the Secretary of State who conducts the review. There was no equivalent procedure here which required the Secretary of State to conduct a review of exculpatory material, for example, upon receipt of evidence from the appellant. And that was what happened in this case was that the appellant, upon receipt of the initial respondent's bundle, started to prepare his own documents for the FTT proceedings, adduced those. There was no review in response to them.
His bundle was rejected in its entirety?
No. It wasn't that the bundle was rejected in its entirety. It's that the tribunal considered. So it didn't exclude the evidence by refusing to admit it. It treated it as irrelevant.
Yeah. That may have been right or wrong. I think you say it was wrong in the light of the authorities as they now stand.
In the light of the authorities as they now stand, exactly, yes. But
so if what you're complaining about is something went wrong in the FTT, where in a properly regulated FTT that material would have been taken into account, how can that support what I understand to be your case, that this was all unfair because there was no intermediate review?
Because what would happen in SIAC is that the Secretary of State would review. This is why the error is Secretary. So SIAC is the protector of fairness and of fair procedures. Those fair procedures are the Secretary of State's procedures. So the Secretary of State takes a decision, receives further evidence, and SIAC, the target of the SIAC review shifts to the updated assessment by the Secretary of State. In this case, there was no updated assessment by the Secretary of State. So the error is not just the tribunals, the error is the Secretary of State, because it's the Secretary of State who has not updated her decision in light of new evidence. That would be our first complaint. The second complaint is that the Secretary of State did not disclose early in proceedings the policy on which she was relying, or we refer to it as a policy, but in any event, the advice which she had received and accepted, which made clear the threshold which she would apply before she made a deprivation decision. And because of that, because that policy wasn't available, it wasn't available at the time of the decision, and because there was no procedure for addressing the Secretary of State again, Mr Kolicaj never had the opportunity to address the Secretary of State on the question whether he fell within that policy or not.
Say that it wasn't serious organised criminal activity.
No, he didn't say that. He said that it wasn't the highest, the highest profile and most serious organised criminal activity, which is what the policy required. And that was a submission which was properly open to him. It was never considered by the Secretary of State.
What weight could be placed upon the probation report if your client didn't give evidence, so that he could be challenged about some of the information that led to the formation of that report?
My Lord, the probation report, the conclusion of the probation report was not disputed. That's why there was no factual dispute. No one has suggested there were any factual disputes before the First Tribunal. Mr Kolicaj did not dispute his conviction. He didn't dispute the trips to Albania post.
I'm so sorry. I thought you said the probation report was excluded by the FTT.
So it was.
So it wasn't admitted on the basis that all facts referred to in it were accepted as being true. But my understanding of what you said so far is that it was excluded, so it wasn't material before the FTT.
My Lord, so it was treated as not being material to the questions which the First Tribunal had to determine.
And if it had been, he would have been subject to a bit of cross-examination about it. Wouldn't he?
My Lord, no, there's no reason to think so at all. There was no suggestion that the Secretary of State considered that the probation report was wrong. It was not. It was the Secretary of State's case was that she had obtained, and my Lord, maybe I'll take you through it afterwards. But her case, the case that she maintained, was that she was entitled to assess risk of reoffending based only on the offence, and she was not therefore required to look at a probation report. So there was no dispute as to the assessment itself. The Secretary of State simply said this is not relevant, and we say that we don't have to say, we don't have to prove that the Secretary of State was wrong about any of this. We simply say that Mr Kolicaj didn't have the opportunity to make submissions about that, and that's because the tribunal did not understand what it would now understand, no doubt, in light of your Lordship's judgments in U3. It didn't understand the uses it could put new evidence to, and it didn't understand, the Secretary of State didn't understand, that she might be required to review her decision in light of it. My Lords, I've overrun.
Well, if that's a convenient moment, we'll adjourn until 2 o'clock. When we resume, it might be helpful for us to be taken to any discussion of this in the judgment of the FTT.
My Lord, yes. I fell into the error of trying to give a 5-minute summary at the start, yes, and that was a very poor misjudgment, I'm afraid.
Happens to us all at some point.
Thank you.
Yes.
The court will adjourn.